STEELE versus State.
Good morning.
Morning.
Timothy Daniel on behalf of William Stewart STEELE. Mr. STEELE has been incarcerated since 1991 or thereabouts after a conviction of homicide. He filed an appeal, a direct appeal of his conviction, which was heard and denied by this court. In the matter before us, Mr. STEELE had filed his own notice of appeal with this court, and that was to be dismissed pursuant to an order of this court directing that no further pro se proceedings be accepted by Mr. STEELE. I subsequently filed a notice on his behalf and represent him in this matter at this time. This concerns basically an appeal of writ of habeas corpus, which was denied by the trial court, Circuit Court, Orange County, and we're addressing basically Mr. STEELE's right to be heard on his belated, as it were, 3.850 motion for post-conviction relief. This case involves basically the issue of due process. Mr. STEELE is asking to be heard, having been denied access previously. And just as an anecdote, in 17 years as a public defender, I don't recall any court denying a defendant to be heard or cutting him off, as it were. The law favors a defendant's right to be heard, and that's what Mr. STEELE is requesting at this time.
In 2000, after the Supreme Court effectively granted your client the right to file a habeas corpus, he in fact did that in 2000, correct?
Yes, Your Honor, I believe that's correct.
Okay. So this is a second.
Yes, we don't dispute it. He's had numerous post-conviction pleadings. This one, I believe...
So he files the petition for writ of habeas corpus in 2000. It's denied. He appeals. It's affirmed.
I believe that's correct, yes.
Okay. And so now we're going through the same thing again.
Well, it's not. Well, he was never heard on the merits on his 3.850 motion.
He filed habeas.
Yes.
He had a hearing, lost, appealed, affirmed. We're going through the exact same thing again, aren't we?
I don't believe this is the exact same motion that he wants to be heard by this court.
Is there anything that wasn't known at the time of the 2000 habeas corpus?
Well, my understanding is Mr. STEELE wishes to present before whatever court appropriate some issues that were not presented by his trial attorney, including some alibi witnesses that were not presented at the time of trial, which is evidence that has come to light after the conviction, which would be grounds for a 3.850 motion at this time. And I don't believe those specific issues were in fact addressed at the previous hearing on his previous writ of habeas corpus. Otherwise, of course, this would be just a duplicate appeal, and I don't believe that's what we're here on, an exact duplicate. There are issues, as I understand, to be heard before the court that have not been previously addressed and have not been actually heard. It appears...
Is there any issue that has come to light after the 2000 habeas corpus proceeding that was not known back then? I'm not talking about a new argument or a new theory. I'm just talking about something, new facts. Is there something that wasn't known back at the time of the 2000 habeas action?
Well, I believe the answer to your question is yes, Your Honor, because as I understand it, Mr. Steele filed a separate writ of habeas corpus, not to tie up the courts, obviously, but because there is, in fact, new evidence to be presented. And I believe he might not present a duplicate argument or duplicate facts at a new hearing, but with the assistance of counsel, whether it be myself or someone else, would in fact present new issues before this court. That is my understanding. I don't have his motion drafted as of this time, of course, because I don't know if it will be heard, but I do believe there are issues that have not been res judicata and determined by this court that need to be determined. So basically, if you see the timeline in the brief, it appears that Mr. Steele's motion may have come some 4 days after the 2-year deadline, and of course that may be 4 days too late. But there is case law allowing for such belated motions and belated appeals. Our argument, of course, is that instead of cutting off his rights, he should be heard in this matter, because he alleges that his 2 years was calculated from the time of the mandate and not when it was actually received by the trial court. So in other words, if this matter is denied by the court, his rights will in fact be cut off. And he does have issues to be heard by the court. As I say, with the assistance of counsel, I think that may make a difference as to his previous attempts. It may not, but if you don't hear his motion, he'll spend the rest of his life in prison. If you do, he may not. And of course, if his current motion or writ is denied by this court, that's basically the end of the line for Mr. Steele. So we're asking for one final opportunity to allow him due process in this case, which I believe he has a right to at this point, and would probably be his last attempt at that. I say I have some time left, but that's basically what I wanted to present to the court. If you have any questions. Thank you.
So essentially what you're doing is making an equitable argument.
I think it's essentially an equitable argument. And
in other words, his position was, I thought Kehoe agreed to represent me, and he committed legal malpractice by failing to do so. He had a hearing on that. The trial judge said, no, that's wrong. And so now this one is basically, okay, so I was late, hear me anyway. Is that where we are?
The lateness, it just is the procedural matter. If we get beyond that, which I hope this court would, then he has, as I understand it, substantive grounds to be heard, which are not a duplicate of his prior hearing. Things that the attorney did or did not do at trial, yes. I believe the trial court's denial in Orange County was basically procedural. But if we can get beyond that, I think he has substantive grounds. And if he's cut off at this point, then it'll never be heard by this court. And as I understand it, he's got nothing else, and then he'll, as I say, spend the rest of his life in prison. So we're just asking the court to at least give him due process one final time.
Okay. Thank you. You got about 5 minutes left.
That's all I have at this time. Thank you.
Well, you may have something on rebuttal, depending on what opposing counsel says.
Thank you.
He's a very loquacious fellow.
May it please the court, counsel. My name is Wesley Height, and I represent the state on this case. This is simply a rehashing of the story that's been told many times. Looking at the appendices that were attached in the record below, Mr. Steele argued in 1995 that he was entitled to a mailbox rule. The court denied it. This court affirmed. In 2003, he argued they called the clerk. It was denied by the trial court and affirmed by this court. He, in the middle of that, tried to blame Mr. Kehoe. They had a hearing on that, and he was denied relief, and this court affirmed on appeal. I believe when I researched this, I found 28 cases just in this court alone. He's been given his due process. He's been given an opportunity. Rule 3850 has exceptions for timeliness. This case does not fall into any of those listed exceptions, and this case is 16, 17 years old. And again, we're repeating the same arguments we've seen time after time. I would ask that you affirm the trial court below and deny relief.
Okay, so maybe you don't need to respond to anything, but you're welcome to.
May I respond?
Of course.
I had a whole series of questions, but he sat down.
We can get him back.
No,
He can
it's
take
too
some
late
time.
now.
I respect Mr. Height, and I think he does a very good job on appeals. As a public defender, I dealt with appeals. I didn't do many myself, but I respect the state's position. But our contention is this is a murder case. There couldn't be anything more at stake. The man's life is at stake, and if he's guilty, if he has no recourse, then he will probably die in prison. But if the court gives him a chance to be heard on what I believe are substantive issues, if it's denied, then he will have his chance. If you cut him off, there's nowhere to go.
Well, there's got to be an end to these proceedings, and certainly Mr. Steele has had many. What I'm having trouble extracting from you is, given all of these, he's had, the untimeliness, the mailbox rule, blaming Mr. Kehoe, all of that has been before the court on one or more occasions, has it not?
Yes.
And having been before the court, and the court having decided, what should impel us to start all over again and rehear all of these things? If the court, the first time that it heard an untimeliness argument in favor of Mr. Steele, decided against it, why should this court, or why even could this court, do anything different?
Well, Your Honor, I understand your point, and I respect that. And I realize there's a good reason that this court entered a specific order specifying that the clerk no longer accept pleadings from Mr. Steele that are pro se. I undertook this case because I hate to sound corny, but I believe in justice, and I believe in our system, and he hasn't had an attorney on any of these pleadings. He has had some opportunity to be heard at one point, but I don't believe he's been effectively represented in this case, whether it be a trial or an appeal. I would like the opportunity to do that one final time. And to answer your question, I think this is the end of the road, as I think I said earlier, for Mr. Steele. This is his last shot. If this is denied and whatever ruling came before the court is upheld, I don't think he can file anything before this court, and I doubt he'll find another lawyer to do that, which he has to do at this point. So we're asking a small amount of your time to decide whether justice has been done, and if it has, then we can live with that.
Thank you, Counsel. Final case.